See, my lord, I pray for permitting us to move and petition today, my lord. They were master rule workers appointed. In the meantime, government has given a fixed pay. But so far, the recent instruction, my lord, the government is making some arrangement to cancel or in the name of verification. They are trying to discontinue their service, my lord. So, my lord, tomorrow, my lord.
May it please your lordship. Lordship, I beg to my item number 27 and 28, lordship. In this case,
Item number
27 and 28, in this case, lordship says fix, take the 3 matters, lordship. Only 2 matters has come, similar issues. So, lordship may,
Who is for the other
I
side?
have already consulted the petitioner, lordship, and both have decided, lordship, to mention it, lordship.
Mr. K. Gogoi and counsel appearing for the respondents submits that both these writ petitions were earlier tagged with WPC number
WPC 45623, lordship,
456 of
23,
2023,
lordship.
but the said writ petition has not been listed today. In view of the above, a prayer has been made to list all the 3 cases together after a week.
Lordship may fix it on second week of
After a week.
lordship.
Since the prayer is not opposed by the Senate Council for the petitioner, same stands allowed, list accordingly.
Oblige, lordship.
May it please your lordship. I beg to mention item number 40, lordship, or 40, lordship.
Yes,
Can be allowed to withdraw, madam. As per
withdraw.
withdraw.
Sure. Why you want to withdraw?
Lordship, as per instruction of my Mikhail Ayn, lordship.
Action. Mr. R. Ali, learned counsel for the writ petitioners, submits that he has instructions to withdraw the writ petition, and therefore the same be disposed of on withdrawal. The learned standing counsel, Revenue Department, Assam, appearing for the official respondent, does not have any objection if the prayer is allowed. In view of the above, this writ petition stands disposed of on withdrawal.
It please, your lordship. In item number 50, we have filed one affidavit. Same I kindly call for.
Item number,
50.
you are for whom?
I'm for respondent
Respondent number?
2. One affidavit we have filed.
All right,
Let
you
me-
get it.
let us-
Well, item number 23, my lord. In this case, my lord, I'm required to file one IA, my lord, to withdraw the affidavit, my lord. I've taken consent the other side, my lord. It is, my lord, it will be supposed to file on next week, my lord. So, my lord, may come matter may on next week, my lord.
No,
Withdraw
which item? You
2023, my lord.
Yes, arbitration petition.
Yes, my lord.
What do you want?
Next week, the matter may come, my lord. I've taken consent of the other side, my lord.
After 2 weeks, with the consent of the learned counsel for the petitioner, comma, Mr. S.K. Mehdi, learned CGC appearing for the respondents, has prayed for adjournment of the admission hearing of this case for 2 weeks on the ground that an interlocutory application is required to be filed in the matter. Full stop. Considering the ground on which the prayer is made and also the fact that the prayer is not opposed, same stands allowed. Let this matter be listed after 2 weeks.
Valuable.
May it please, your lordship. I'd beg to mention item number 7, your lordship.
Hmm.
I'm praying for withdrawal of the matter, your lordship. There are subsequent developments. We have filed a representation and the Director General, the BSF, has responded to it. And also some facts were left out, your lordship, at the time of filing the petition, your lordship. So we may be permitted to withdraw and file afresh, your lordship.
Mr. H. Buragoyal and counsel for the petitioner submits that there have been certain subsequent developments changing the nature and character of this writ petition, and therefore he be granted leave to withdraw the same with liberty to file afresh. The prayer is not opposed by Learned CGC appearing for the respondent. In view of the above, this writ petition stands disposed of on withdrawal with liberty as paid for.
Obliged.
May I please, your lordship? Your lordship, this matter may be listed for admission on 2nd of February. Matter pertains to non-payment of bill.
Go to the correct bench. This is not the bench. It's a bench for matter, non-payment.
May it please your lordship. Lordship, I pray for a listing of one old repetition for hearing
Hmm.
on 6th of the February.
No,
It is-
the hearing that, like, it cannot be, you get it for orders after 10 days,
Lordship,
right? For orders, then we'll see whether the matter is ready. Yes,
already a written rule has been issued.
all right, but we'll see whether it is
Yes,
ready.
lordship.
For orders, after 10 days for orders, yes.
May I please, your lordship, item number 49, kindly pass over the matter for the date,
Item
Because my-
49,
because, yes, 49, because my senior is not well,
but it's a orders matter.
yes.
On the prayer of learned counsel for the writ petitioner, this matter has passed over for a week.
May it please your lordship, lordship, I beg to mention for listing for admission a matter for next week, lordship. Any day next week, lordship,
No, next week is not possible.
then day after next.
Third week of February.
Third week of February. Oblige your lordship.
May I please your lordship, I beg to mention for listing of a matter. Lordship, it is a promotion matter. We are entitled under the 10% quota for promotion from grade 4 to grade 3, lordship. Some vacancies, so lordship, next week.
Third week of February.
May I please your lordship, I beg to mention item number 8, a matter may be passable for the day and another day may be fixed.
You are for whom? Yep.
Deepika,
You are appearing for whom?
petitioner.
On the prayer of learned counsel for the petitioner, this matter stands passed over for the day. Yes.
Daily list for motion item 1.
Lordship, case is in regard to not placing of the case of the petitioner before the DLC, lordship. We have filed one affidavit, lordship, para number 8. And para number 8 and para number 17, lordship, we'll place the case, we'll place this case in the next DLC, lordship. That's why it has been stated.
The affidavit is not on record, but do you have a copy? Can you get the affidavit? Get the affidavit. Just give a copy. Have you received a copy of the affidavit?
No, it, lordship.
No, but you'll place it in the next DLC for what?
No, thing is that his case was not placed before the DLC. That was his thing. If he placed his case before the next
He
DLC,
had submitted application when?
lordship, in that regard, lordship, para number 6 may kindly miss.
When
No,
did he
thing is
submit?
that, lordship, as no application was made to the respondent number 4 directly and in prescribed manner, and to without providing any information regarding alteration of name of Prasenjit Chakraborty to Pritam Chakraborty, besides the claim of the petitioner was time barred of more than 23 years elapsed after
Respond number 6 by register.
Deeply obliged.
Published.
May it please, my lord, the petitioner case was rejected by DLC, my lord. We are against that, my lord. On the ground that, on the date of submitting application, he was a minor by few months, my lord. But the proposal was
When
considered.
was the scheme withdrawn? Compassionate appointment scheme, when was it? withdrawn?
Lordship since 2017 and
Which month?
2017 April. Let me give you. First April, no? 2017. And Lordship
So
here.
when was the application submitted?
Application submitted in 2017, my lord, 21/6/2017.
So by that time, the scheme was withdrawn. Then,
No, my case was considered by the authority, my lord, after 6 years. During that time, it was not placed.
yeah, but then by that time, the scheme was already withdrawn. The
What are-
authorities don't apply their mind in these matters.
Yes.
They work like machines. You see, just now somebody said 23 years back,
My lord.
somebody died. So now they want to consider it.
No,
They
only,
don't apply their mind, even if they have it. I don't know. Complete non-application of mind is happening. We'll have to dismiss your petition, Mr. Burwa. It can't be helped.
my lord, your lordship will issue notice, my lord, on this,
Lordship, on the
I-
date of application, the petitioner was minor, Lordship. This
No,
is there.
that was not the point, my lord.
Yes.
If we consider the 1 year period, my lord, by the OM, my lord,
This scheme was withdrawn. How can you get employment under a scheme which was not there?
if your lordship will see kindly page 47.
What I said about the government officials, I don't want to say about the petitioner's
But
lawyer.
there's
Unless you
rejected-
compel. Court.
That is not written here, my lord, regarding a scheme.
All right, heard Mr. B. Burwell and a counsel for the petitioner, also heard Ms. M. Bhattacharjee, learned Government Advocate Assam, as well as Mr. N. Upadhyay, learned Standing Counsel Irrigation Department Assam, appearing for the official respondents. First of all, the claim of the petitioner is for appointment on compassionate ground due to the premature demise of his father, who was a government servant. Full stop. It appears that the father of the petitioner died on 13/3/2017, but at that time, he was a minor. Full stop. Subsequently, at that time, he was a minor. Petitioner had submitted his application seeking compassionate appointment on 21/6/2017. When he submitted application, he was still a minor.
Yes,
By
Lordship.
few
On the
months,
date of
only 5
submission.
months. But there is a law by Supreme Court that,
He was a minor. Full stop. However, the application of the petitioner was not placed before the DLC. Hence this writ petition. Full stop. What is to be noted here in that the scheme, the appointments on compassionate grounds were made under the scheme floated by the government of Assam, which was withdrawn with effect from 1/4/2017. Full stop. At present, there is a scheme for providing compassionate family pension, but but there is no scope for entertaining any application for providing providing appointment on compassionate ground. Full stop. Since the scheme for appointment on compassionate ground itself was withdrawn prior to the date of submission of the application, and also at a stage when the petitioner was still a minor and hence not eligible to apply for such an appointment, there is no scope for this court to entertain this writ petition and issue a writ of mandamus. Full stop. However, if the petitioner is otherwise eligible to seek compassionate family pension, this order would not come in the way in making such an application in prescribed format before the competent authority. As such, by granting liberty to the petitioner to apply for compassionate family pension as per the existing scheme, this writ petition stands closed. Yes.
obligation.
My lord.
I'm here for praying for my consideration of the letter dated 3/10/2023 at page 42. My lord, what has happened, my name was, the petitioner's name was recommended for the, for promotion. However, the BTC,
is the necessary party, Lordship,
we have made them the party.
but
we have
probably
not-
name was not shown, Lordship, has not been
And
shown.
we just need consideration because the promotional council has not been set up. So matter may be disposed of.
Moreover, Lordship, the petitioner were engaged against personal post, Lordship. They are not entitled for promotion, Lordship.
My lord, the department itself has recommended our name at page 42, annexure 10.
Lordship, you have just said, Lordship, they
I am
do
here only for
do
consideration of
not
this
apply
letter.
their mind, Lordship.
Consideration of this letter, my lord. Only consideration of this letter by the promotional committee and with a given period of time. And matter may be disposed of, man. That is what I'm suspecting.
Is this case again after a week by reflecting the name of Learned Standing Council BTC in the Congress?
Obliged,
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 sir.
Lordship.
May I please, your lordship, in this case, my lord, the SOCOS notice was issued on 21/3/23. Thereafter, enquiry officer was appointed and enquiry was fixed on 8/9/23, but no document affixed with the SOCOS notice was not furnished to the petitioner. In the circumstances, petitioner has approached this honorable court, and this honorable court might order dated 7/9/20.
counsel appearing for the writ petitioner peruse the amendments made in the writ petition. The petitioner has approached this court for the second time, assailing the enquiry report dated 30/11/2023, bracket annexure 21, inter alia contending that the enquiry report is not only vitiated by complete procedural irregularity, but the same is also in violation of the directions contained in order dated 7/9/2023, passed by the learned single judge passed by this court in WPC number 5197/2023. Full stop. Mr. Sinha has further argued that although a number of documents were relied upon in the enquiry proceeding, the copies of the same were never served upon the petitioner. Thus, thus causing serious prejudice to his interest. First up, Mr. V. Rajgopal, Learned Standing Counsel, Cooperation Department, Assam, raised for some time to obtain instruction and file affidavit. In view of the above, issue notice of motion returnable on 6th of March 2024. Since Mr. Rajko has accepted notice for response numbers
1 to 5, Your Lordship.
1 to 5, and Miss M. Bhattacharjee, Learned Government Advocate Assam for response. She's additional senior. You are additional senior Government Advocate Assam.
Civil supplies.
Additional senior Government Advocate Assam for response number 6, 7, and 8. Service of notice is deemed to be complete in this case. Extra copies of the writ petition, requisite in numbers, be furnished to the Learned Departmental Councils so as to enable them to obtain instruction and file affidavit. Hard on the prayer of interim relief, it is submitted at the bar that no further action pursuant to the enquiry report dated 30/11/2023 has been taken by the authorities till date. First up, in view of the above, it is hereby provided that no further action be initiated based on enquiry report dated 30/11/2023 till the returnable date.
Obliged, highly obliged.
Item 6.
Your Lordship, on 25/1/2024, I was allowed to participate in the training. That is the 59 batch of pre-promotional cadre course. But whether I'm confirmed or not, Your Lordship, that is not there. I've only been allowed to participate.
Yes.
Lordship, we have been informed that the case of the petitioner has been put under seal cover, Lordship. This is there, and they have been allowed to, petitioner has been allowed to go for the next training, Lordship, in spite of their being in the seal cover.
So why it is on the seal cover?
Lordship, that instruction I don't have, Lordship.
No proceeding is against me, Your Lordship. No departmental proceeding.
Get the instruction, Lordship.
So when is the next training?
Next training, he already has been informed, Lordship. Next training.
I have already joined the training, Your Lordship. This is the.
Which will be started from today, Lordship, 29/1.
So all right, then interim, you got the relief
Yes, Your Lordship.
and let them file affidavit.
Yes.
Lordship.
Mr. T. Devi, Learned Counsel for the petitioner is present. In terms of the order dated 22/1/2024, passed by this court, Ms. M. Bhattacharya, Learned Additional Senior Government Advocate Assam, appearing for the state, has obtained instruction and submits that the writ petitioner has been allowed to participate in the ongoing training program, which commences from today, that is 29/1/2024. Insofar as the other allegations made in the writ petition, Ms. Bhattacharya submits that as per instructions received by her, the consideration of the petitioner for confirmation is kept under seal cover, but she prays for 4 weeks' time to obtain complete instruction and place the same on record. In view of the above, issue notice of motion returnable on 9th of on 11th of March 2000. Should it be 4th of March 2024, since Ms. Bhattacharya has appeared and accepted notice for all the respondents?
Lordship. I am appearing for,
All
yes,
the respondents.
all the
No formal
respondents.
notice is required to be sent in this case, extra copy of the expedition, requisite numbers, etc., etc., etc. List on 4(3).
Deeply obliged.
Please, your lordship.
So against order of dismissal. from-
My lord, my lord.
We'll have to issue notice then.
My-
But Mr. M. Sharanyal and counsel for the petitioner. The petitioner is primarily aggrieved by the order dated 27/2023, by means of which he was dismissed from service. Mr. Saranya submits that the appeal preferred by the petitioner has
My
also
lord.
been rejected
On-
by the appellate authority by order dated 22/11/2023. Full stop. Peruse the grounds taken in the petition. Full stop. Ms. M. Bhattacharya, learned additional senior government advocate, asking praise for some time to obtain instruction in the matter and file affidavit. In view of the above, issue notice of motion returnable 11th of March 2024. Since Ms. Bhattacharya has appeared and accepted notice for respondent numbers 1 to 4. No
Lordship.
formal notice is required to be sent to the state respondents. Extra copy of the writ petition, requisite in numbers, be furnished to the learned government advocate so as to enable her to obtain instruction and file affidavit. Petitioner to take steps for service of notice upon respondent numbers 5 and 6. Let the matter be listed on the returnable date.
Deeply obliged. Your Lordship.
May I please?
Yes,
Aganmadi occurs, your lordship, of BTC, your lordship,
BTC.
BTC.
BTC council is present. So here notice has to go because there is a private respondent. Heard Mr. N. Upadhyay, Learned Counsel, NN Upadhyay, Learned Counsel is hearing for the writ petitioner. Peruse the amendments made in the writ petition. Assailing the selection and appointment of the respondent number 6 as Anganwadi worker in the number 2 Koirabari Anganwadi Center. The instant writ petition has been filed inter alia contending that although the respondent number 6 had scored lesser marks than the petitioners, yet she has been arbitrarily and illegally appointed by ignoring the candidature of the writ petitioner. Full stop. Mr. B. Chaudhary, learned SC BTC, and Mr. C.K.S. Barua, learned Assam, have both prayed for some time to obtain instruction in the matter. Issue notice of motion returnable in 4 weeks. Since Mr. C.K.S. Barua has accepted notice for respondent numbers 1 and 3.
No,
Only 1.
1 and 3.
Huh?
No, Tamulpur is lordship under BPC.
Lordship,
What about Deputy Commissioner?
Sorry, yes, 1 and 5.
1 and 5. And Mr. B. Chaudhary, learned SC BTC for respondent numbers 2
3 and 4.
and 4. Service of notice upon the said respondents is deemed to be complete in this case. Extra copy of the writ petition, requisite in numbers, be furnished to the learned department council. Petitioner to take steps for service of notice upon respondent number 6 by registered post with AD.
Item 11.
May I please, your lordship?
Yes.
Lordship, here in the case, lordship, to implement the Jal Jeevan mission, lordship, the respondent authorities has started a public water supply sector under Jal Jeevan mission in Bausargoti village in the district of Dhuburi. Lordship, as per the guideline, a water user committee was formed on 18/11/2021. And thereafter, the Water User Committee selected the petitioner and recommended him for the engage as a Jolomitra for maintenance of the public water supply sector. But here the respondent number 4 had impugned order dated 17/10/2023, ordered the respondent number 5 to engage private respondent number as a Jolomitra, Lordship.
Well, issue notice, nothing more can be done now.
No, Lordship, the Water User Committee, Lordship, is a self body, Lordship.
Yes. If you succeed, we'll make it clear that any appointment made during the pendency will be subject to further orders. Yes, heard Mr.
Is
AZ
it,
Ahmed, Learned Counsel for the petitioner, peruse the amendments made in the writ petition. The petitioner is assailing the recommendation made in favor of respondent number 8 for appointment as Jal Mitra of Basurputi PWSS by contending that there was an earlier recommendation by the designated committee.
Water User Committee.
Water Users Committee to appoint the petitioner as Jal Mitra. Full stop. According to Mr. Adhan, the exercise leading to replacement of the petitioner in the recommendation is wholly arbitrary and illegal. Full stop. Ms. M. Kalita, learned SC PHE, praised for some time to obtain inspection in the matter. Issue notice returnable in 6 weeks since Ms. Kalita has appeared and accepted notice for respondent numbers 1 to 5, Your Lord. 1 to 5, no formal notice is required to be sent to state. Extra copies, requisite numbers, etc., etc. Petitioner takes steps for service of notice upon respondent numbers 6, 7, and 8 by registered post with AD. Heard in the prayer of interim relief. Having regard to the facts and circumstances of the case, it is hereby provided that any appointment to the post of Jal Mitra, made during the pendency of this writ petition, will be subject to the final order that may pass in this case.
Obliged, Your Lordship.
May it please, my lord. Fact of the case is that, my lord, the petitioner is an advocate, my lord, since practicing from 2007, my lord. And in letter pursuance, letter dated 17/4/2023 by the respondent number 2, he applied for the post of additional notary public, my lord. But his name was not sent, my lord, by the Soraidev Bar Association, my lord, respondent number 5, my lord. My lord, he is practicing from 2007, my lord.
We'll ask them to obtain instruction.
Yes.
Motion still 1 week. Heard Mr.
M. Kolika, my lord.
M. Kalika, and counsel for the petitioner, taking note of the grievance of the petitioner that despite having submitted his application for appointment as additional notary public in Saraidur district, his name has not been forwarded by the authorities. Ms. M. Bhattacharjee, learned additional senior government advocate Assam, is granted a week's time to seek instruction, preliminary instruction, and appraise this court as to the correctness of the allegation made in the writ petition. 2 extra copies of the writ petition be furnished to Ms. Bhattacharjee. Let this matter be listed for motion again after a week.
My lord, on 5th February, there is an interview board, my lord, and following letter issued, my lord.
We'll see. A pendency of this writ petition will not be a bar to redress the
Yeah.
grievance of the petitioner in accordance with law, if so advised.
Deeply obliged.
Wait, please, Your Lordship. My lord, the petitioners are honorary Gao Buras in the district of Dhubri, my lord, who were appointed as per the procedure prevalent at that point of time, my lord, and without any remuneration, my lord. My lord, as per the advertisement dated, my lord, 6th of July 2018, my lord, my lord, page number 74, my lord. My lord, it was issued by the Deputy Commissioner Dhubri for fresh appointment with a remuneration of rupees 6,500 per month, my lord. My lord, a fresh recruitment seeking to obliterate the earlier Gao Buras, my lord, is not permissible under the law, my lord, because they will rendering the duties from the beginning, my lord. And my lord, as per the order dated 11th of August 2022, my lord, in paragraph 7, my lord, it has been clearly stated that my lord, the Gauburas, they form a class of their own, and some weightage is to be given to the Gauburas. And in paragraph 8, my lord, it was given that whether the petitioners are the Gauburas or not, to examine that, my lord.
You are aggrieved by the advertisement.
Yes, my lord, we agree with the
One minute.
advertisement and the order dated 3rd of January 2023, my lord.
Where is that?
My lord, page 141, my lord.
Yes, what does it say?
My lord, in this order, my lord, second paragraph, the Commissioner and Secretary in the Revenue Department, Government of Assam, to take a decision on the same as to whether the writ petitioners form a class apart from the other intending candidates, as to enable them to a weightage. And if the Commissioner arrives at a conclusion with a reason order that they do form a class apart from others, appropriate provisions may be made in the manner acceptable under the law for some kind of weightage is in the selection process, my lord. My lord, this order, my lord, the order dated 11th of August 2022, my lord, it has been clearly stated in paragraph number 7 that they form a class apart. In paragraph number 8, it has been to examine whether these petitioners form a class apart or not, my lord. The Revenue Department has extracted only paragraph number 8, not
Acha,
the earlier.
1 minute.
Yes,
Where
ma'am.
is the order of the court where this direction was passed?
My lord, page number 139, my lord. Paragraph 7, my lord.
So this advertisement is of July 2018.
Yes, my lord. The initial advertisement, my lord. 6 July 2018. The court ordered that, my lord, they form a class apart. And in paragraph 8, it was stated that to examine whether the writ petitioners, they are the Gauburas who form a class apart or not, my lord. But the Revenue Department on 3rd of January 2023, my lord, they extend only one paragraph, not the main paragraph, which states that they form a class apart and weightage is to be given to them, my lord. They picked and choose a paragraph, my lord. And my lord, the honorary Gauburas have been rendering their duties from the beginning. And my lord, if a new selection process takes place, my lord, their right will be violated, my lord. Because my lord, it is not a sanctioned post, my lord. It is.
Yes.
Let me go. Lordship, my lord. The honorary Gaubura, these are working, my lord, as per the, my lord, that synopsis of this case, lordship. They are appointed by the, my lord, that Gaon Sabha, lordship, not by the any district authority. And lordship, my lord, and they did not.
No, apart from that, she wants that this order of the learned single judge
Lordship.
at page 137.
Lord-
See that. See the order once, 147. She
One-
wants this order to be honored. Is it not?
Yes, my lord.
Lordship, my lord, in percentage, that order, lordships, lordship, my kindly goes to the page 141.
Yes.
Page 141, some inquiry has been made by the, my lord, that deputy commissioner, through deputy commissioner, by the, my lord, that department lordships.
Hmm.
And as lordship may kindly see, third paragraph,
Yes.
whereas the deputy commissioner Dhuburi White, letter number so and so dated 10/11/2022, submit the report with regard to the following queries. These queries were made.
Hmm.
Madam, I will have to point out that, Madam, a NEEL report was submitted by the Deputy Commissioner Dhubri, Madam, not a report, a NEEL report, my lord. The Deputy Commissioner could not submit any report, my lord. Personally.
You see, I can issue a notice here today,
Yes, my lord.
but it will end in dismissal ultimately because,
But
listen.
Yes, my lord.
First of all, whether weightage is required to be given or not, that will depend on facts of each case.
Yes, my lord.
So in a read petition where number of petitioners have clubbed in, no mandamus can be issued. That will make it very clear. So if at all you want to make a claim, the court will have to look into the facts of each case and come to a conclusion whether this is a fit case where weightage should be given. Even if the facts are identical, it cannot be painted in one brush, painted by one brush. This is number one. Number two, there is a order which has to be set aside.
Yes, my lord.
So what do you want to do?
My lord, it is not it is a civil post, my lord, not
We'll
government
issue
under
notice this way.
not a sanction.
Lordship, kindly see the page 139, page paragraph number 9, Lordship.
Yes.
139. Because of the pendency of the repetition, some of the repetition were not able to submit their application pursuant to the advertisement that is so and so, Lordship. And as the
The
selection.
problem is you have to apply, even if it is another class and weightage.
Yes,
Without
my lord.
applying, have your clients applied in terms of the advertisement dated 6/7?
Yes, but some of them have applied, my lord.
Who have applied?
My lord, they have applied, my lord.
All of them.
Yes, my lord.
Where is the
My lord,
statement?
my
Where
lord,
is the statement?
my lord, we will have to file an affidavit and my lord, the ones we have applied,
No,
my lord.
where
To
is
make it
the-
clear, my lord. To make it clear, my lord. Yes, my
All
lord.
right.
My lord, because my lord, in paragraph 7, my lord, clearly it has been given that a weightage is to be given, my lord.
Oh, weightage will be given, but first you come to that stage.
Yes,
no?
my lord. Yes, my lord. I get it.
If you have to apply, you have to be eligible, you have to fulfill all other norms. Then only the question of giving or not giving weightage. It can't be that I don't fulfill anything, but give me weightage, give me that. There is no such direction and such direction cannot be implemented. So you have to clarify on that.
Yes, my lord, we'll clarify
then,
next week, my lord.
If some people have applied, some people have not, your writ petition will be dismissed on that ground. I mean, that is the principle. Whether you get an order in another form, in another court, I don't know. But that is the principle. It will be a misjoinder of cause of action. How much time you want to file in this?
My lord, 2 weeks time, my lord.
On the prayer of Ms. P. Barwal and a counsel for the petitioner, this matter stands adjourned for 2 weeks so as to enable her to file an additional affidavit. Mr. J. Handek, Standing Counsel, Revenue Department, Assam, and Ms. A. Talukdar and G. Assam are present on behalf of the official. Have you understood?
Yes, my
what I
lord.
pointed out.
Yes, my lord, whether they form, my lord, they have submitted or not, my lord.
Weightage comes much later. They have to be proper applicants. They have to apply. The projection is that they need not apply. But that's not correct. That cannot be accepted. Only the question of weightage will arise if they all take part in the selection process and on particular criteria, some weightage, extra marks can be given to them. That is only on one criteria, that is experience, nothing else. On all other aspects, they have to qualify. Where are these statements?
Yes, my lord. Fine, affidavit. Deeply obliged.
Item 14.
Yes, Mrs.
My please, my lord, here, my lord, the petitioner along with others, my lord, have been selected for my lord RCC training, my lord. Recorder certificate class training, it is for eligible for Mondal, my lord. So, my lord, accordingly, BTC has approved a list, my lord. The government has approved the list for training, my lord. So, accordingly, they have to plan the, my lord, training course period, my lord. And from last 17, this will support, my lord, start, my lord. In the meantime, BTC has prepared another list, my lord. Another list has been prepared, but that has been not, my lord, only they have declared the result. And without communication to the government, my lord, to the training authority, my lord, they have admitted in place of us, my lord. That is my case, my lord. Lordship may come to the, my lord, where annexure 1, my lord. These are the candidates provided by BTC, my lord, for training. To the response number 1, my lord. Names are, my lord, with the, my lord, address, my lord. This is the letter, my lord, and approved on 28
So
March
which is the first list where your name was there, page number?
page number, my lord, 23, my lord.
Hmm.
These are the names, my lord, has been approved by the PTC, my lord.
Approved by the petitioner,
My lord.
approved by the petitioner.
My lord, BTC, my lord.
BTC.
BTC authority, my lord, for training.
So there are 12 petitioners hearing.
We have 12 approves, my lord.
Hmm.
Thereafter, my lord,
Where is your name? Which are the serial number?
my lord, Rotsime, please. I have category stated in paragraph, my lord, 4. The petitioner number 1 appeared in serial number 12, my lord.
No, can you just indicate?
My lord,
Who are the candidates?
Rotsime, serially, my lord, page, serial number 3, my lord.
Ah.
Petitioner 8, my lord. Serial number 5, petition number
Number
6,
is not required. You just point out who are the people who are before this court.
my lord.
Serial
Serial number 3, my lord.
in the 12.
Serial number 5,
Hmm.
serial number 10, serial number 12, serial number 16, serial number 19, then my lord, serial number 32, then my lord, 38, my lord, serial number 38. Then my lord, 89, 90, my lord, serial number. Then my lord, 91, my lord.
89.
Then my lord, 112, 113.
112, 130.
And 147, my lord.
So this entire list has been changed.
My lord.
Entire list has been changed, or only these 12 people have been left out.
No, my lord. Entire list has been sent, my lord. Different list has been, my lord. They have newly proposed, my lord. There has been, my lord, admitted for training, my lord.
Where is the other list?
Other list, my lord, lordship may come to page 50, my lord. Annexure 7, my lord. No list, my lord. Only result has been declared on, my lord, 12 January 2024, my lord. And in the bottom, my lord, they have said that you have to appear before the training authority, my lord. Bottom paragraph, my lord. Of that. Only this is a result, my lord, with roll number, no names.
And the earlier list, people were not allowed to take
Not
part.
allowed to join. They have been admitted, my lord.
Yes, Miss Bora, what is the matter?
Lordship, I need to take instruction, Lordship, let it be a day after tomorrow.
You also obtained this. One extra copy each.
My lord.
Heard Mr. M. Saravanan, I called the petitioner.
No.
The parents governments made in the petition.
Oh. One was no?
Having regard to the
Oh.
nature of allegation made in the writ petition, to the effect that after the list of candidates were finalized and the same had received the approval of the government of Assam, the BTC authorities have changed the list for imparting RCCC training course, thus depriving the petitioners of their genuine rights. First, comma, the learned departmental council are to obtain preliminary instruction responding to the above plea. One extra copy each of the writ petition be furnished to Mr. J. Handick, learned SC Revenue, and Ms. R. Bora, learned SC BTC. Registered to list this case again on 2nd of February, 2000.
My lord, second may not be, my lord, maybe. My lord, second day I have a trial court at Nagaon, my lord, there's lynching case.
Trial court, oh.
That, my lord.
Monday, fifth. Deep level.
My lord.
It must be a big trial, Mr. Saranya.
My lord, that is already, my lord, only 313s remain, my lord. All are examined.
Must be a very fat trial.
My
If
lord,
they are taking you to the trial court, huh?
my lord,
Yeah, good, good.
my lord. My lord, that regarding lynching matter, my lord, obviously, my lord.
All right, all right.
But in this case, my lord, the petitioner has been dismissed by the ONGC, my lord, after retirement by the impugn order dated 13/4/2023, page number 201, my lord.
They're challenging the order 13/4/2023.
Yes, lordship. They've challenged this because this is not as per that they have not followed their own rule, my lord, while conducting their departmental proceedings, my lord. And the authority who is supposed to conduct the departmental proceeding, he has not. It is done by the lower authority, my lord.
Will issue notice of this. Heard Mr. Reportcaster and counsel appearing for the writ petition appearing the amendments made in the petition. Assailing the order of dismissal dated dismissal from service dated 13/4/2023. Bracket annexure numerical 9. Bracket 2. The petitioner has approached this court inter alia contending that the imperial order is vitiated due to several procedural irregularities inasmuch as the respondents have not followed their own
Service rule, my lord.
service code while conducting the departmental proceeding against the petitioner. Mr. After hearing the arguments of the petitioner's counsel, this court is of the view that the matter would call for deeper examination. The notice of motion returnable in 6 weeks. Petitioner to take steps for service of notice upon the respondents by. You are appearing?
I'm appearing on behalf of Mr. S.S. Roy. He's on legs in another court.
No, but who's the respondent?
1, 3, 4, 6, 7, and 8.
Mr. S.S. Roy, Learned CGC appears and accepts notice on behalf of respondent numbers 1, 3.
1, 3, 4, 6, 7, and 8.
1, 3, 4, 6, 7, and 8. As such, no formal notice is required to be sent to the said respondents. Extra copies of the writ petitioner, requisite numbers be furnished to the learned standing counsel so as to enable him to obtain instruction. Petitioner to take steps for service of notice upon the remaining respondents by registered post with AD.
This matter pertains to completed appointment. We applied in the year 2017. My father died in the year 2016. The application was rejected only on the ground that applied after stipulated time. So though we filed in the year 2017, immediately after the death of my father, that application was not considered. Then again, we filed an application.
When was it filed? Application was filed when?
Application was filed on 4/1/2017. It is available at page 19, though not in proper format. But subsequently.
Let them file affidavit, then we'll issue notice. Heard Mr. S. Biswas, counsel for the petitioner, peruse the amendments made in the writ petition. The petitioner is aggrieved due to non-consideration of rejection. Yeah, rejection of her application for appointment on compassionate ground. First of, Mr. N. Upadhyay,
I'm for 3, lordship.
SC Irrigation Department Assam, and Ms. A. Talukdar, Learned GR Assam is present for the respondents. Issue notice respondents and have prayed for time for instruction. Notice of motion returnable in 6 weeks. Since Mr. Upadhyay has accepted notice for respondent numbers 1 and 3 and Ms. Talukdar.
Lordship, I'm for 3, lordship.
Huh?
I'm for 3 only, lordship. GAD is there, lordship, respondent 1.
You inform me. Ms. Talukdar has accepted notice for respondent numbers 1 and 2 and Mr. Upadhyay for respondent number 3 as such service on notice came to be completed in this case. Extra copies will be furnished to the learned department.
May please also. So this is regarding appointment to the post of president of a school management committee. Now, what has happened here is I have challenged the appointment of the private respondent on the ground. I was also a selectee in that particular panel for president. What had happened is the particular person who has now been selected, the rules provide that I must be a parent to a children who is studying in that particular school. Rule 13, I can place that rule. Now, this particular private respondent, somehow to be eligible, what he has done is he has shown her daughter to be therein as a co-senior student of that particular school. Now, for a co-senior student, the minimum age has to be 5 years. Now, her age, if a lordship will come.
Wait a minute, is it a government school?
Yes, government school. Government school, as per the rules, appointments are to be made as the post of president of the school management committee.
So this is school teacher's case. Why it has come to this?
Not school teacher, lordship.
Yeah.
It's that particular committee which is headed by the parents of that school for the development and management of the school, as per the rules, Rule 13, lordship, of the rules of 2011.
1 minute. What is the name of the school?
Number 1, Kodomani Pothar Balika Muktab School.
Is it a government school?
It's a government school.
The government school, there is a managing committee of private individuals.
As per the rules, lordship, 2011 rules.
What do you have to say?
Up to obtain instruction also.
No, it's everything is clear. I have just produced that particular document of the girl. If a lordship will just see 2 pages. If your lordship will first come to page 17 for a moment. Page 17, the
Yes.
managing committee is reduced in writing as below. Majida Khatun, lordship sees that is the petitioner for the post of president. The student is class 4, right hand side row. And number 3 is Zakir Hussain, a private respondent. The name of the student is Zakia Asrifa Shreni. Now I'm just placing her document that we have obtained from the Kodomoni Pothar number 1 Anganwadi center, because she is a primary student. At page 29, if your lordship will come to page 29, the student unique number is page 29, Annex 3. The student's
So,
unique number is there.
1 minute, you are assailing the participation or selection of Zakir Hussain?
Selection, page 26 is his approval. He has been now selected
Selected for appointment as?
as the president of the school management committee, bypassing my legitimate claim, because I was otherwise in the panel number 1.
So now, why you are saying he is not eligible?
Because the rules provide that to be a president of that particular body, your ward must be a student of that particular school. That is rule 13(1) Roman B, Roman 2B. I'll just place that.
All right.
Now, if your lordship will come to now page 29, lordship has seen that in the particular reduce to that panel, the student's name and the particular year or the particular class that he or she is studying has been recorded. The reason for that is because of the rules. Now, if your lordship will come to page 29, Zakir Hussein's daughter is Zakia Asrifa. Page 29 is a document that we have obtained from the Anganwadi center where she is otherwise studying, being a primary level student. The unique number is there, that can be also verified by the government. The first student's unique number, that's a unique number. Now, lordship will see her age 1/3/2020.
All right, so she is not a student of that school.
Exactly. She is a student of the Anganwadi center because her age is below the age of a student who would otherwise study in a course training.
All right, now.
So in collusion, they have done this.
Now, the private respondent has already been appointed.
My instruction is that the approval has come, but that he is not functioning as such now. The approval is here at page 26. But approval will thereafter fructify into an appointment. That is yet to come.
So why don't you tell us what is the position?
My prayer would be that at least he should be stopped from working because he's not eligible.
On 5th of February, you tell us. Give us the response, otherwise we'll stall it.
Till then, it must be stayed, lordship. My humble prayer.
You have to
Because
wait.
otherwise he is not eligible. He is not eligible.
If they confirm it, we'll ask the authorities not to allow him to function.
Yes.
But Mr. Sharma and a council for the.
Interim will be considered on the next date, lordship.
Selection of the respondent number
5.
5
5.
for appointment as the president of the managing committee of
Number 1, Kodomoni Pothar, Balika Muktab School. In the synopsis.
number 1, Kodamani Pothar,
Balika Muktab
Balika
School.
Kadamani Pothar, Balika Muktab School, on the ground that he was not eligible under Rule 13 bracket
1.
numerical 1 bracket close bracket Roman 2 small Roman 2 bracket close bracket small b bracket close of Assam right of children to free and compulsory education rules, 2011 to be appointed as president of the society, since his ward was not a student of that school at the relevant point of time. Mr. Sharma has prayed for setting aside the selection and approval of the authorities for appointment of petitioner. First up, Ms.
S. Kuwar.
S. Kuwar, Learned Standing Council, Primary Education Department, Assam, prays for time till 5/2/2023 to obtain preliminary instruction and address this court on the grievance expressed in the writ petition. A prayer aloud. Let this writ petition be listed again on 5/2/2024 as a fixed item for motion. 2 extra copies of the writ petition will be
Yes, ma'am.
furnished to Ms. Kaur. You tell us what is it, otherwise we'll, in any case, we'll pass an order stopping it. You have to tell us whether he was eligible or not, and if so, how the allegation of petitioner is wrong. If these 2 things are not done, we'll stall. We'll ask that he should not be allowed to function. That order is coming on 5th. Yes.
Obliged, Your Lordship.
Yes. The covered cases.
Covered,
Covered.
my lord, but this is the prayer, my lord, extension of the select list, my lord, validity of the select list. my lord. This annexure 6, my lord,
Hmm.
page 41 to 44, my lord. This select list was published, my lord, 31st 1/2023, my lord. So, my lord,
Yes. You are appearing?
My lord, for Guwahati University, my lord.
Yes.
My lord, we have already published on 31 January 2023.
Hmm.
So, my lord,
That is what he's saying, the extension is
Lord,
what he's seeking, because of those,
my lord.
those
those
pending.
medical boards verification, my lord. We don't have any objection, my lord, regarding extension of validity.
Further 1 year?
My lord, we don't have any objection, my lord.
Yes, Mr. Badua.
I'm very good.
All right, you are appearing for? Respond numbers? Yes, heard Mr. S.K. Royal and Council appearing for the writ petition. Here is the amendments made in the writ petition. It appears that pursuant to an advertisement notice dated 30/12/2018 issued by the authorities for filling up a number of backlog vacancies in the categories of grade 3 and grade 4, which were reserved for persons with disability, bracket PWD, W small. The petitioners had applied and were the writ petitioners hearing had submitted their application and were eventually selected in as much as their names were included in the select list published on 31/1/2023. First up, the petitioners were selected by accepting their benchmark disability, within quotes, benchmark disability, as per the certificate issued by the competent authority. However, subsequent to publication of the select list, the petitioners have once again been subjected to scrutiny by a special medical board and special medical board so as to assess their disability, so as to assess the extent of their disability. Mr. Roy submits that the petitioners have been advised to question the findings of the medical board in case of those candidates where there is a difference between the opinion of the specially constituted medical board with the benchmark disability certificate issued by the nodal agency. However, since the select list is expiring on 31/2024, unless the validity of the select list is extended for a further period of 1 year, the interest of the petitioners would suffer serious prejudice. First up, responding to the above, Mr. P.J. Fukan, Learned Standing Council, Guwahati University, appearing for the respond number 6, Miss R.M. Decker, Learned Standing Council, Department of Social Justice and Empowerment, appearing for the respond number 4, and Mr. C.K.S. Boa, Learned Junior Government Advocate Assam, appearing for the respond numbers 1, 2, 3, and 5, have all submitted that if the prayer of the petitioner is only for extending the validity of the select list, they would not have any objection in that regard.
It should be confined to the 5 petitioners.
However, they would not have any objection to the said prayer, subject to the condition that the order of this court be confined only to cover the cases of the 5 petitioners. Full stop. Mr. Roy, learned counsel for the petitioner is also agreeable to such an order. In view of the above, without expressing any opinion on the merit of the claims and counterclaims of the parties insofar as the question of benchmark disability is concerned, this writ petition is being disposed of by providing that the validity of the select is dated 24/1/2023. Bracket annexure.
Annexure 6, page
Annexure
41 to 44.
The validity of the selected is so and so. Annexure 6, page
41 to 44.
page 41. Annexure 6 page na lage, huh? Annexure 6 shall stand extended for a further period of 1 year with effect from 30/1/2024. However, the present order would be applicable only to the 5 writ petitioners in the present proceeding. However, this order would be applicable only in case of the 5 petitioners in the present writ petition. With the above observation, the writ petition stands disposed of. Yes. You have missed the bus.
My lord, there
You
are
thought
some.
you will first get an order and then keep coming one.
No, actually,
That is going to be difficult now. You have missed the bus.
There are some other petitioner in where the interim order has been passed, my lord. In other cases, it is reserving the post, my lord. But this order will affect them, my lord. My lord.
I can't say. What do you want then? What do you want?
Entire
It
select-
should be made entire select list. I will say that this prayer is rejected. That will not be given even if you file a petition. Because today the select list is expiring. It cannot be extended tomorrow. You missed the bus. I know what you wanted, but you have missed the bus. I'm so sorry. Yes.
Made clear. Lordship, after filing this petition, they have issued the appointment orders, Lordship. Therefore, you need to challenge the appointment firstly, and secondly, the selection committee needs to be a party on. Otherwise, the respondents are not eligible on the last date of application. They did not have the RCC as required by the advertisement. Page 18 was the advertisement.
So record course will issue notice because one training has already commenced. So even if you.
Not for the training, this is
Not
for
training,
my lord,
not training.
selection for the post of my lord Latmundal.
Not Mandal.
Lordship.
Achha.
They already been, they were made a party, my lord, that those who are my lord STP, my lord, there is a quota.
But on 23rd, this petition was filed. On 25th, it is reliably learned that appointments have been made, Lordship. Therefore, we need to challenge the appointments also.
Let the notice be issued.
Present writ petition may be allowed to withdraw liberty to challenge the
Alright,
appointment.
Mr. BP Bora, and counsel for the petition submits that there have been certain subsequent developments in this case which are required to be brought on record, and therefore the petitioner will be granted leave to withdraw this writ petition with liberty to file afresh. Mr. J. Henry Lanet, SC Revenue Department, Assam, and Ms. N. Bhattacharjee, Lanet G. Assam, appearing for this state, are present and do not have any objection if the prayer is allowed. In view of the above, this writ petition stands disposed of on withdrawal with liberty as paid for. Yes.
Obliged, lord.
Supplementary list the motion item. It is same that of item 6, Lordship, but here whether this is in seal cover or not, that I am not aware,
My lord,
Lordship. He has been sent to training.
Yes, my lord. She has been allowed to undergo.
It is same as item 6.
Yes, Lordship.
So all right, we will issue notice.
Oh, yes, Lordship. And this is
Mr.
fixed on
D.K.
11.
Lanet, counsel for the petitioner also heard Ms. M. Bhattacharjee, Lanet, additional senior government advocate Assam, appearing for the state, who submits that the petitioner has been allowed to undergo the training program which has commenced from today, that is 29/1/2024. However, full stop there, however, insofar as the recommendation for confirmation of his services is concerned, you see, her service, this is the lady, fire service is concerned, the same has been kept in sealed cover.
No, Lordship, in this particular matter, I don't have this instruction, Lordship, that particular.
Acha. However, insofar as the remaining allegations are concerned, the respondents be permitted some time to obtain instruction and file affidavit. Issue notice of motion returnable in 6 weeks since Ms. N. Bhattacharjee landed the additional government advocate Assam has appeared and accepted notice for all the response.
1 to 5 years, Lordship.
What about 6?
6 is
It's
private.
principal, my lord, the police academy, my lord.
Oh, Lordship,
why
then
do you
I can
name it?
appear, yes, Lordship.
1 to 6, no formal notice, extra copies. Let this matter be listed along with item 6
Yes, Lordship, on 11th,
on 11/3.
Fourth-
Note
okay,
is
okay.
returnable on 11/3.
Yes. 4/3.
Huh?
4/3.
Acha.
It was later.
4th of March, okay, 4th of. Same order as an item 6, and so returnable date.
Order stay vacated, item 20.
My lord, I am for the writ petitioner and an application has been filed by FCI. But Mr. Vinod Singh, he told me that he is unwell. He'll be seeking an adjournment. So you are for? So he is not keeping well. Counsel for FCI.
So
So,
what is to be done?
my lord, he's told me to fix a date after 27 because he's having back pain and all this. 27th of February. Any date after 27th of February.
You will be happy to do that. Extend some.
My lord, I'm submitting on the instruction that
Your name, please?
Mrs. J. Begum.
Mrs. J. Begum, learned counsel for the applicant, bracket FCI, submits that the arguing counsel, Mr. B.K. Singh, is unwell and has been advised bed rest. Therefore, this matter be adjourned for 4 weeks. Mr. S. Chakravarti, learned counsel for the writ petitioner stroke OP, does not have any objection to the prayer. Mr. A. Chandran, learned senior government advocate Arunachal Pradesh, is also present on behalf of the state of AP and does not have any objection to the aforesaid prayer. In view of the above, on the request of the applicant's counsel, these matters stand adjourned for 4 weeks. List the case again on 4th of March 2023, 24 as fixed item. Interim order passed earlier to continue.
For admission, item 21 and 22.
May it please, my lord. My lord, these application was for section 468 of the Companies Act for delivery of property. Whatever remaining assets and properties and documents which were with the directors are handed over to the previous OL. However, thereafter, because of the change in the official liquidator, the new incumbent liquidator is still preparing the report for finalizing. And once the report is prepared, we'll file it and then my lord may dispose the matter of.
Mr. S. Sandhya, learned counsel appearing for the OL, submits that the process of preparation of the report is at an advanced stage and therefore 4 weeks further time be granted to place the same before this court. In view of the request made by Mr. Sandhya, these matters are directed to be listed again after 6 weeks. In the meantime, the report be brought on record. Report of the OL be brought on record.
No.
OL money official liquid.
My lord, Mr. GN Samuel is on legs, my lord, after some time.
You are appearing for whom?
For the respondent, my lord.
What about
For the petitioner, my lord, sorry. For the petitioner.
And where is the counsel for the petitioner?
Yes, he's
The
there.
respondent?
Morning I had a word.
What do you want?
My lord, there is a section 11 application, my lord.
You want a Passover?
Just for time being, my lord.
All right. Pending Passover.
Item 25.
May I please, your lordship? Lordship, in this case, lordship, in the petition as well as in the affidavit in reply, we have mentioned it as a proprietor, but actually it is a partnership firm. So we have filed an amendment petition today. And the copy has been served on him.
Just now I have received this copy.
You have anything to say?
My lord, nothing, my lord.
No
I have no
objection.
objection, my lord.
That is an IA.
Not I, yes, 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 I.
What is the IA number?
Lordship, I guess number also there too. Does
IA is not listed. The learned counsel for the petitioner is submits that an interlocutory application has been filed on behalf of his client recently, seeking amendment of the arbitration petition, but the same has not been listed. Mr. A.K. Datta, learned CGC appearing for the respondents, has confirmed that he has received the copy of the IA. The registry will therefore trace out the IA, tag the same with the record of this case, and list the matters together again for admission.
Date may be fixed, my lord.
Date fixed 5th of May, 29th of April.
Timing matter, I can bring.
Please. This is regarding appointment of arbitrator, my lord. The railway matter, my lord. Those, your losses.
Yes, it is a contested case. What are you opposing the prayer?
My lord,
Why?
my lord, as per the contract agreement, my lord, there is a clause, my lord, which stipulates that more than 20, if the claim value is more than 20% of the, my lord, contract amount, my lord, then the dispute is not arbitrable.
You raised that under section 16. That will not go into. That will
But-
amount to,
Because, my lord, we have rejected the claim by stating that, requesting them to reduce the claim amount, my lord, to less than 20%. My lord, we have filed the affidavit in opposition and we have replied
where
to.
is the clause? Which clause?
My lord.
That point has been considered by the sole court, my lord, already. And that's a reported judgment.
No, we have annexed-
To GLT 759. The details judgment, my lord. Paragraph 57 onwards, my lord.
So same view here.
Yes.
The land single judge is also saying the same thing.
My lord.
This is the matter to be raised before the arbitrator.
No, but I am relying on a Delhi High Court judgment, my lord.
That is not.
Which has rejected.
Delhi High Court has not- हाँ. है.
Paragraph 15. A single claim.
So is the aggregate value above 20%?
Yes.
No,
You have accepted it.
no, not less than my individual claim for this, our High Court has considered it. This claim which we are making here.
Mr. Sarwala, I am asking a simple question. According to them, the dispute is not arbitrable.
Yes.
Since it is less than 20%. Aggregate
No, more than.
No,
20%.
more than 20%.
more than 20%.
More than 20%.
No.
What is it?
It is not more than 20%, less than 20%. This claim you
So
are.
where have you said that it is less than 20%? Where is the statement?
Well, that you have noticed. Yeah, your losses must see.
Which paragraph?
A reply, my lord, your lordship. This entire affidavit, my lord, page 282 onwards.
Page?
282 onwards, my lord.
Para 14.
Yes, Sarah?
Para 14, my lord. It starts from para 7 also, brother. It starts from para 7, but also. Directly consider. Directly consider.
It is stated that
No,
only a single application upon maintenance.
So, Mr. Gupta,
My lord.
Delhi judgment doesn't come to play here.
My lord.
The reason is, in this judgment, it was admitted that it is less than 20%. But here they have disputed it.
Not, one, there, we have rejected, my lord, their application also on that
No,
ground.
what you have done is
My
not
lord.
binding on us.
My lord.
What is binding is the precedent. They are saying it is more than 20%, you are saying it is less than 20%. This is a matter the arbitrator will have to decide.
Yes.
That's all.
No, my lord, we are on the claim amount itself. My lord, will see our reply at page 280, annexure 2.
All right. 5 minutes you will get. After that, we'll dictate the order. We'll allow the petition. There is nothing. You are simply wasting the time. This is a decided matter, covered case. What is there for you to argue? Is this not covered by this judgment? Have you read this
My
judgment?
lord, arbitrable tribunal can decide, my lord, on the issue. In that case, my lord, it can be disposed of, my lord, by giving a direction to the tribunal to decide on the arbitrability, my lord, of the
Mr.
claim.
Gupta, you don't seem to have read the arbitration law at all.
My lord.
There is no need for direction. These are all statutory mechanism. You can raise that plea before the arbitrator. Arbitrator will decide whatever plea is raised. Have you read section 16?
My lord,
Have you read or not?
yes, my lord.
What does it say?
My lord, the jurisdiction of the tribunal, it can be questioned before the
Yes.
tribunal itself.
Yes.
16.2, my lord.
Yes. So you are to raise question on jurisdiction.
No, that liberty may be.
Take down.
3 members may be appointed, my lord. 3 members, my lord, one will suggest. Or
3 member.
better, my lord, I think.
So where are the, give the names? of
Yeah,
arbitra-
our name has been given, my lord.
What about your name?
Last page, my lord, we have given our name.
Mr. Gupta, who is your arbitrator?
On that, I have to take instructions, my lord.
Justice E. Padma Nabham. At page 261, we have given one.
In one letter, एक letter में लोग नाम दिया थी.
And they have given in the letter 3 names, my lord. They can appoint anyone.
Where are the 3 names? There is- No, you want the court to appoint 3 arbitrators.
Well, 2 arbiters will be appointed and
Yeah.
they will appoint the presiding arbiter.
All right.
They are agreeing to it, my lord, can be appointed only.
Anyone?
Anyone. And what is the name of your?
Our name is at page 261, my lord, page.
Page 261.
Justice E.
Justice E. Padmanabhan, retired former judge of the Madras High Court. The last paragraph.
No.
All right. I'll pass the order in the chamber.
Well,
We'll get it tomorrow. Leave it in the chamber.
They are making the same prayer, my lord.
What is the matter about?
This is regarding appointment of Anganwadi worker, my lord. The petitioner has appeared in the selection process and her name appeared in the first, my lord. At page 29.
Cancel
She
rule.
is the first position and it was also.
What is your
sanctioned.
instruction?
Your lordship, entire selection process had been cancelled, your lordship, and accordingly, the respondent number 7 brought the matter to the notice of the public wide office notice dated so and so
on 4th November 2022, Your Lordship. And the respondent number 7, the CDPO and member secretary submitted comparative statement of the candidates who appeared for interview, Your Lordship, for the post of Anganwadi worker and helper by the order dated 22/6/2020, Your Lordship. That we like to bring it on the records, Your Lordship.
You want the affidavit to be filed or not?
Yes.
Then you have
So
to-
then we can reply.
Yes.
Otherwise, you don't have any case. You have to close it.
My lord,
Heard Ms. S.
without-
B. Chaudhary, learned counsel for the petitioner. Also heard Ms. P. Das, learned SC BTC, on whose prayer further 4 weeks' time as last chance is granted to the BTC authorities to file affidavit. Ms. M. Bhattacharjee, learned additional senior government advocate Assam is present on behalf of the state respondents.
Deeply obliged.
My prayer for confirmation of my service, my lord. I was appointed as part-time worker, my lord, in the year 1991. And hereafter, in 2013, my service was upgraded as full-time worker. But till date, my service has not been confirmed by the department. This is my prayer, my lord.
Yes.
Well, we have filed our affidavit and we have stated that, my lord, the main grievance of the company is that, my lord, often she is on, my lord, unauthorized absence, and there are so many complaints for many staffs. That is the only reason why she could not be confirmed yet.
But no, mandamus will go now. That can't be a ground note.
My lord, I leave all up to your lordship. my lord.
Heard Mr. Your name please, A. N. Ahmed, learned counsel appearing for the writ petitioner. Also heard Mr. S. Datta, learned senior counsel assisted by Ms. S. Musari, learned counsel appearing for the respondents. Stuff. The writ petitioner hearing was initially engaged as a part-time sweeper, wide appointment order dated 19/4/1991. Subsequently, her services were upgraded. Wide office order dated 21/8/2023. However, despite having rendered service for more than 21 years, the petitioner is yet to be confirmed in service. Aggrieved thereby, confirmed in service, as a result of which she has been denied all service benefits, including annual increments.
No,
and all.
the annual increments she is getting, my lord.
Achha.
The medical benefit, all these things she is getting.
As a result of which the petitioner has been compelled to approach this court by filing this writ petition. Mr. Ahmed submits that the petitioner belongs to the scheduled caste community and she has been sincerely rendering her services as a sweeper. Therefore, as a sweeper for last 21 years. For over 21 years. Therefore, there is no good ground for the authorities not to consider her services for regularization. The respondents have filed affidavit in opposition. A perusal of the affidavit in opposition. It appears that the petitioner has been working as a sweeper since the date of her engagement in the year 1991. However, according to the respondents, she has remained periodically absent from duty, as a result of which the prayer for confirmation of her services could not be accepted by the authorities. Mr. S. Datta, learned senior counsel appearing for the respondents, has however fairly submitted that periodical absence from duty could have been a ground for disciplinary proceeding, if at all, but same cannot come in the way of considering the prayer of petitioner for confirmation of her service. Has submitted in his usual fairness. Full stop. Having heard the learned counsel for both the sides and in view of the fact that there is no dispute regarding the continuous service rendered by the petitioner as a sweeper since the year 1991, this court is of the opinion that there can be no valid ground to deny uh, and also the submission of Mr. Datta that the petitioner has been extended all service benefits, including annual increments and medical facilities. This court is of the opinion that there is no valid ground for the respondents not to act upon her prayer for confirmation in service. As such, this writ petition is being disposed of by issuing a writ of mandamus upon the respondents to consider the prayer of the petitioner for regularization stroke confirmation of a service and thereafter pass appropriate orders in accordance with law. The aforesaid exercise be carried out and completed as expeditiously as possible, but not later than 3 months from the date of receipt of a certified copy of this order. The petition stands closed.
Much obliged.
Mr. Lordship, I have inquired in the office, Lordship, it is not be filed, it not filed yet, Lordship. So I have handed over the file to them, Lordship. Asking them to file the same within a very short period of time. So, Lordship,
We'll have it on Friday. You're available. Second. Mahad Mr. H. Alamgir, learned counsel for the petitioner on the request of Mr. Sikir Burwa, learned Government Advocate Assam. This matter is directed to be listed again on 2024. In view of the assurance given by Mr. Burwa that on or before 1/2/2024, affidavit on behalf of the department shall positively be brought on record by serving advance copy upon the petitioner's counsel. But if it doesn't happen, then you know what order is coming. Get ready for that.
I'll try 200%, Lordship.
No, we'll have to call the DC for personal appearance by reflecting all these things. You have to file it. Court proceedings cannot now progress in a cavalier manner. Those days are over. Yes, whatever it has to be done, whoever has to take whatever steps. Time is the issue now. People will have to be focused. Whatever is to be filed has to be filed. Because people are thinking that the judges and courts are not working.
No.
We can't allow that perception to go on. So we will dispose of matters quickly. Yes.
This matter, your lordship, the petitioner was a daily wage worker. But he has made an application in the NIOS. So he made an application initially for, he was there for 19 years, who made an application for regularization of his service. This court by an order has directed that his regularization be considered. Till his regularization has been considered, he may not be terminated and no person should be appointed in his place. Thereafter, what has happened, there was a criminal case was issued wherein some answer scripts were with regard to NIOS of class 10 and 11, there was some manipulation of answer scripts and all, in which the name of the petitioner have also been incorporated. Though he has not been arrested, he is being allowed to appear on trial. So he has appeared in the trial, gave his evidence. Now the authorities have issued a single line order saying that since there is a criminal case against you, you are terminated, you are disengaged from the service. I have come after that. Now the criminal trial, he is not arrested, there is nothing against him. There is a punitive order where they have specifically stated that you are not terminated.
Where is the order? Where is the impugn
That
order?
impugn order, your lordship will find at page impugn order, your lordship will find at page in the main writ petition unit.
Which is the page number, Mr.
Just a
Mahan?
moment. I have given the page. Yes. 66. Hmm, 66. Discontinuation of engagement of Bhaskar Medhi, daily wage staff. As per office record, Bhaskar Medhi has been engaged on so and so. The office in receipt of CBI inquiry, where it has been mentioned that Mr. Medhi was in criminal conspiracy matter of so and so. examination held in 2007, you are therefore disengaged. Now, there are two things, your lordship. This is on the basis of punitive order, because it is on the basis of a CBI inquiry where there is some kind of criminal conspiracies there. Though he is just accused and nothing, the trial is going on. There are hundreds of, it is an all India issue. A trial is in Bhopal. He appeared in the trial. Now the question, and also there is another order of this on the court where it says that you cannot terminate him without considering for consideration. That part there. So this is a termination on the punitive part. If there's a punitive termination, then your lordship 311 of article comes, because that cannot be done. Your lordship just on this
So
single.
is there any stay of this order, 2911?
No, no, he has, after that we have come. So there is no stay, because he has already been disengaged then.
And are you saying that there is contempt of the order of this court?
No, I'm not saying contempt, because two things have happened here. This termination was on the punitive side. Though the earlier order of this honorable court was with respect to the fact that he should not be terminated without considering his case for regularization. So he has not been considered for regularization, and and second part was in the order that no other person should be appointed in his place. So these two part have not been done so, and then he has been. In the meanwhile, he has been terminated by this order. Here they are trying to point it that yes, this is termination not on the basis of the earlier High Court order, but on the basis of the fact that there is a criminal case pending. And if there is a criminal case pending against the person concerned, it's a punitive order, then there has to be.
So you are saying he is entitled to the protection of Article 311?
Yes, if that is.
But do you have any decision which says that this Article 311 will extend even to daily wage workers?
Because your lordship, there are two protections. First and foremost, if it is a punitive order, then 311 comes. I'll come with you. Second part, your lordship, there is also an order of this honorable court said you cannot be terminated, simply cited without he's considered. It's not been considered. This part, with regard to the judgment, I have not bought the judgment.
If you say that because of the court's order, he could not have been terminated.
Yes.
Which you are entitled to.
Yes.
In that case, you cannot say that there is no contempt. Then you have to file a contempt proceeding.
No.
Otherwise, it will amount to
But
waiver.
this is a subsequent order passed, your lordship, on the basis of which they have brought in another factor, that is the criminality. So
Then-
that has to be, I don't have the decisions now. If your lordship requires, I can get some decisions on the basis of which, in such case.
We don't require anything. If you want to argue your case in a particular manner, you are free to do it.
Yes.
Or if you want to conclude it today, you do it.
No, I can place these two things. First is that there is an order of this court, you cannot terminate. That order, your lordship may.
No, but that will not take note.
Number
because
one.
You have not filed any contempt case.
No, contempt you have not.
Then
Contempt
that-
you have
that
not filed
argument
because
will
this is a writ petition because of the second order of disengagement, this order of disengagement, which we are challenging him on the basis of the fact that he is entitled to continue with till his regularization is considered.
So
That is one.
only point is violation of Article 300.
That is second part is violation of 300. These are the 2 points.
What do you want to do? Argue today for final disposal?
Yes, but the judgments I don't have. If your lordship.
We
wants-
don't want anything. It's up to you. Whatever you present on the
No,
basis.
I have only this much of argument, pardon.
Then should I reserve the order? Without filing contempt case, you can't allege there is a violation of the court's orders. There are judgments on that. You can't. Because it will amount to acceptance and waiver, and therefore the court on its own will not go into that aspect.
Though we have taken the plea here in this petition with regard to the said fact.
But it appears it's a case of contempt of court's order. There is an order not to discharge him
Yes.
without considering.
Without consideration for his regularization. That is the first part. And second part, nobody should be appointed in his place. That part, we are not concerned. But the first part is there. And second part is that now you have disengaged without that, number one. And second is that this is a punitive order, so 311. These are the two factors.
So what do you want to do?
Lordship, in that case, let it have it some other day, your lordship. In that case, I may also be having some orders for if your lordship requires. But the contempt matter, that is a factor. I need to think about it, but
So you need this matter to be posted on
some other day, your lordship.
when do you want it?
Any day. I mean, not on fifth or sixth, apart from that. any-
There is an order not to terminate him without considering his,
My
yes, why have you done it?
my lord, I am for respondent number 5, my lord, as per direction of Assistant Director, because of the criminal case, it was order in P order 29 November 2022. I was asked to
No, where
listen.
is the law that if there is a criminal case initiated, the employee should be terminated? Where is the law?
My
Where is that law? See, there is an order of the court, don't terminate him before
My-
considering his case for regularization,
lord,
right? Despite that order, the director has terminated him
my
on the ground that a criminal case is pending. Now, that could be a valid reason if there is some provision in the statute
my
that moment there is a criminal case pending, service will have to be terminated. But unless that is there, you cannot interpret the court's order like this.
lord.
So give us the name of the director, we'll call him in person.
Now, my lord,
Yes.
kindly have a look, 29th November 2022, my lord, impugn order, my lord.
Hmm.
This was passed on the basis of the order was passed Assistant Director, my lord. He has directed us. My lord, may I read, as per record,
You are appearing for whom?
respondent number 5, my lord,
Who is respondent number 5?
Regional Director, my lord. Page 78, my lord, of my affidavit. As per office order.
And where is the order of the court not to terminate? Where is
That
that
your
order?
lordship is a judgment. Start from 29. Page 29.
Page 29.
Page 29 onwards, you know. And relevant part
Last pair.
in page 34, last paragraph. Page 34, para A. So there is a specific order on the.
You are lucky that they have not filed any, they are not pursuing their right. Otherwise, your client would be in serious trouble. You're very lucky they are not pursuing it. Yes, what do you have to say?
1 to 6,
except
5. He is agreeing for 5. PGC,
Hmm. What is your stand?
my lord, I have not received any instruction, although I have communicated all the.
We'll adjourn it on your prayer. Mr. Manan, counsel for the petitioner, 4 weeks further time to prepare and argue the matter on merits. Mr. P.S. Bhattacharya, learned CGC, appearing on behalf of the respondent numbers 1 to 4 and 6. Some is that he is yet to receive any instruction in the matter. Mr. J. Lashkar, learned counsel for the respondent number 5, some is that his client has acted as per the directives of the respondent number 6 man in this case. Full stop. Be that as it may, in view of the request made by the petitioner's counsel, let this writ petition be listed for admission hearing again after 4 weeks. In the meantime, the respondents may obtain instruction and file affidavit. You have filed affidavit?
I have already filed it.
In the meantime, the respondent numbers 1 to 4 and 6 may file affidavit if so advised. Prima facie, this is in violation of the court's order.
Lord. Hablan. Más obliged.
एखन दिया था Malad, I have received the instructions, Malad, pursuant to the last order. Lordship, the letter dated 17/1/2024, kindly come to the next page, Malad.
Just a minute.
Lordship.
What are the facts of the case?
Like here, he appeared in a selection process, but subsequently, Malad, in the interview he appeared, although he appeared, he was shown absent and he was not given the marks. We have Malad, verified the records and we found that there was a mistake on the part of the selection committee, Malad. Ultimately, they have sought to rectify it. And they have already written to the government, Malad, for seeking approval for holding the interview board meeting, Malad. That instruction I have placed, Malad.
We'll direct you. Where is the question of approval? Court orders now we'll direct you. You have to do it in a time bound manner.
Lordship.
There is no question of approval when there is a read court order.
No, ultimately that number has to be given by the interview board. Since after the board meeting is over, the board is not functional, my lord.
We'll direct the
Yes, yes.
authority to reconstitute the board for.
Yes, yes. Yes. Without the approval of the government, the appropriate authority, the state level police recruitment board is finding some.
No, Mr. Nath, you have to understand, court orders are not subject to approval of the government. We are directing the government. So if the government says, unless we give approval, the court order will not be implemented.
No, there is no court order as of now. If lordship
That's
is
right.
directing, as of now, there is no order, my lord. From our own, my lord, we, after verification of the record, we found.
Just 1 minute.
Lordship.
No, now it transpires that he has participated in the
He participated, yes.
But what happened then no marks were awarded?
He was shown in the final my lord, compilation sheet. He was shown absent. In fact, after verification of the record, we found that he appeared and 5 marks ought to have been, he ought to have secured 5 marks in the interview.
Where are the records?
I have placed that instruction is clear enough, my lord.
That's right, but where is the record? Then why should he again go interview board and all these things?
My lord, what I am submitting, the interview board after the selection, the state level police recruitment board is conducting the selection process.
Yes.
After the final completion of the selection process, they used to submit everything to the authority. Authority used to appoint. Now, after the process is over, the interview board is not in functional manner.
Right.
Therefore, after verification of the record, they have found that this is what has happened. Therefore, the board is to be reconstituted. They have to sit, the board has to.
I follow, Mr. Nath,
Lordship.
but please understand the question I am making.
My lord,
The interview board has given him the marks. Is it not?
not given. Board has not given. Board has shown him to be absent. But ultimately, from the attendance sheet, we could found that he appeared and 5 marks ought to have been given to him. When they have re-verified the records, they found that no.
Why 5 marks? 5 out of?
The interview mark. This is the attendance sheet, my lord. In the attendance sheet, his signature is there, and marks awarded in Viva, it should have been in respect of him, it is nil, my lord. In the sheet, my lord, it is nil, but he was there. But his name is Navadip Roy. He has put his signature in the attendance sheet. He appeared in the interview, but in the second page, lordship will find that no mark has been shown against him.
Correct.
So that mistake, after re-verification, they could found that this is a mistake. Number has not been given. Therefore, now the instruction they have given. Kindly see the second page of my instruction. I'm reading a lot. Based on the report received from the interview board, the state level police recruitment board has decided to award 5 marks for oral Viva to the writ petitioner, namely Navadip Roy, and adding the marks of oral Viva, his total marks for the whole recruitment test would be 89.26, which is more than the cutoff mark for male unreserved category for Constable AB in respect of Gwalpara district. Considering the above facts in circumstances, the Honorable Court, we have informed the Honorable Court, and on last occasion, Lordship has recorded that. Therefore, as the candidate was not awarded any marks by the interview board for his oral, a fresh oral Viva has to be, they said Viva has to be conducted, but the board has to sit and award him mark because the board has not given any mark. It is 0.
All right, then what do you want now? Time, some time.
I need time.
You will give them some time. It's going in your favor.
Yes.
Yes, heard Mr. S. Burman, Learned Counsel appearing for the writ petitioner. Also heard Mr. D. Nath, who has obtained written instruction in terms of the order dated 5/1/2024 passed by this court and has placed the same for perusal by the court along with the supporting records. Full stop. It appears from the instruction obtained by Mr. Nath that although the petitioner had participated in the interview process, no marks was awarded to him by the selection board, as a result of which the petitioner's name did not find place in the final merit list. First of the written instruction dated 17/1/2024 issued by the Inspector General of Police bracket A bracket close Assam and member convener SLPRB, Assam clearly goes to show that a decision has been taken by the authorities to award 5 marks to the petitioner for viva voce. Full stop. If the said marks are awarded, instruction dated so and so issued by so and so goes to show that the authorities are of the view that the petitioner is entitled to 5 marks on account of viva voce test, in which event his total score will go off to his total score in the selection process would be 89.26, which is above the cutoff mark for male unreserved category candidates for appointment as constable bracket AB bracket close in the Gwalpara district. First up, since the petitioner belongs to the OBC category, hence, if the aforesaid exercise is carried out and completed, there can be no manner of doubt that the petitioner would be eligible and entitled to an order of appointment as constable bracket AB. In view of the above and on the request of Mr. D. Nath, Learned Senior Government Advocate Assam, this writ petition is adjourned with a direction the post to matter again on 6th of March 2024 so as to enable the respondent authorities to reconvene the selection interview board and thereafter complete the process for appointment of the petitioner as Constable AB. Full stop. Considering the nature of issue involved in this writ petition, it is expected that the departmental authorities will finalize the process on or before the next date fixed.
My instructions may be kept on record.
You keep it?
Lordship.
All right, the written instruction dated 17/1/2024 be written.
Lordship.
These petitioners were erstwhile employees of Kachar paper mills.
Lordship,
And they have been, after the mill has gone, they are absorbed in the government department as per the policy decision. And as per the policy decision, persons with the required qualifications will be given in grade 3 and those as grade 4. Now he has been given in grade 4, he is engaged, but he's otherwise entitled to the.
He means how many petitions?
The petitioners, 3 petitions, sorry. These 3 petitioners, they have otherwise they qualified for 3, but they were engaged in grade 4. That is basically the case. On the last occasion, my friend has taken time to file the affidavit.
See, I received the instructions day before yesterday on Saturday only. It's a bulky material, Lordship. I seek some time to file an affidavit, Lordship.
You are appearing for whom?
I'm appearing for 1, 2, let's say 1, 2, and 9. Respondent number 1, 2, and 9. Basically, Industries Department, Lordship. Industries Department.
I am appearing for respondent number 4, 5, 6, and 7.
All right, what do you say, Mr. Manan? He wants time to. Your clients is working as in.
No, they are already in the job.
They are
but,
working. They are working.
They are working.
Only thing is that like they are seeking.
Grade 3 petitioner also had Mr. A. Kalita, Learned Standing Council Industries Department Assam, appearing for the respondent numbers 1, 2, and 9, who submits that he has received written instruction only day before yesterday.
Yes.
And therefore be permitted 2 weeks time to prepare an affidavit and bring the same on record. Mr. S.P. Das, Learned Counsel for the respondent numbers 4, 5, 6, and 7, as well as Mr.
My lord, may J. Borman on behalf of J.K. Goswami for AIDC, my lord.
What is
Respondent
the-
number 3.
as well as Mr. J.K. Goswami for respondent number 3 are present. Mr. D. Nath, Learned Senior Government Advocate Assam has appeared for respondent number 8. On the request of Mr. Kalita, this matter stands adjourned for 3 weeks so as to enable him to obtain file affidavit by serving advance copy upon the petitioner's counsel.
Yes.
No, see, as part of lawsuit, I have got to obtain some specific instruction in regard to those FSL report, Lordship. That is still awaited. Dispute regarding facts.
My brother himself came down here, my lord, in the Guwahati High Court, my lord, campus, Honorable High Court campus. Thereafter, put his signature in the, my lord, agreement, my lord, NOC, actually, NOC. And the affidavit, he has shown, but there is a allegation, yes, my lord.
And it
regarding-
is specific instructions of his brother before the police that his signatures has been that what his statement was it, Muhammad Asifur Rehman had submitted a complaint petition against Saful Islam Heed, where the petitioner alleged that Muhammad Saful Islam has taken his signature on a blank stamp paper and made NOC and submitted the same at Assam Police Headquarters without obtaining his consent. After that, Lordship, the concerned additional superintendent of police was given the burden of inquiry, Lordship. He has given the report that accordingly, after completion of inquiry, I have submitted the inquiry report to the Assistant Inspector General of Police through the Honorable SP Walpara, where I open in conclusion of the finding of the inquiry that in order to fully establish the genuineness, originality of the documents, 2 criminal cases have to be registered and the documents have to be sent to FSL for examination with sample handwriting of both the parties. So, Lordship, accordingly, I have written the letter to the concerned party, Lordship. What is the whether any report has come from FSL is a Bangalore, I think, from Bangalore.
This does learned counsel for the petitioner also had Mr. C.K.S. Borwa, learned government advocate of Assam, who submits that the FSL report is still awaited and therefore he be granted further 6 weeks time to obtain the FSL report.
And in fact, Lordship, those 2 criminal cases, whether those were being instituted or not, and at what stage, but if they have instituted.
Considering the importance that the FSL, significance of the FSL report in this case, a prayer made by Learned G. Assam stands accepted. Mr. C.K.S. Borwa to issue reminder for the FSL report. Is this case again after 6 weeks?
Lordship, here in this matter, this morning, Lordship, I have served a copy of the affidavit I have filed, Lordship, this morning.
I have just.
Not on record.
Is it just now I have received?
Affidavit on behalf of?
Respondent number 5.
124 is over, already filed.
You want to?
No, because it is on the basis of notification they are putting on that, so I don't report under. No, no reply is required and maybe fixed because matter is a little pending and one physically.
What is the matter about?
This petitioner is a physically handicapped person. They are impairing.
Your affidavit is not on record, it seems.
Lordship, this morning I
Today
have
only
filed.
filed, my lord.
Then we'll have it after 10 days along with the affidavit.
On 7th, my lord.
All right.
Correct.
Mr. C. Borwa, learned counsel for the petitioner submits that a copy of the counter affidavit filed by the respondent number 5 has been served upon him only this morning. However, the counter affidavit is not available on record. Mr. B.K. Das, learned counsel for the respondent numbers 1 to 4 and Mr. D. Pamanu, learned
Standing counsel.
Standing counsel, Health Department, Assam are present. First up, on the request of Mr. C. Borwa, learned counsel for the petitioner, let this petition be listed again on 7th of February 2024 by taking the counter affidavit of the respondent number 5.
If required, I'll file.
With
Because I have to go
record
through.
of this case, the petitioner is granted liberty to file rejoinder affidavit in the meantime, if so advised.
Obliged.
My lord, I'm for the writ petition, my lord. Bank has recently filed an affidavit. I'd like to file a reply to that.
May I
Which-
please your lordship, Mr. Sharma is legs before another court. May kindly pass over the matter for the time being.
Who has filed affidavit?
Bank, respondent. I'd like to file a reply to that, my lord.
Sure. Mr. S. Chakraborty prays for and is granted
2 weeks time, my
2
lord.
weeks time to obtain instruction and file a rejoinder in response to the counter affidavit filed by the bank. The learned counsel for the respondent bank is present. Let the matter be listed accordingly. Yes.
Much obliged.
May I please, your lordship?
Yes.
My lordship, in this case, my lordship, I have been terminated, my lordship, without following the principles of natural justice. Page 13 may be seen, my lordship. Even the reason of termination also not stated. Page 13. It has been stated that has been found in
3030.
Your
page
lordship,
13, 1-3.
your
one
lordship,
three.
Mr. S. Datta is on legs in another court. The matter
Page
may
1-3,
pass
my
over for the time being.
Just 1 minute. Page 13.
1-3, my lordship.
These similar matters are fixed before this court on 8th of February, perhaps. Do you
Alright,
have
so-
the,
Yes, my lord.
Huh?
This is also covered by the one of your judgment, your lordship judgment, my lordship.
yes, where is the senior?
He is on legs, your lordship, in another court. It may be passed over for the time being.
All right, let him come.
It's my.
Obliged, your lordship.
Here, my lord, we will need further 2 weeks time to file the affidavit. We have received the instructions, my lord. I have sent it for vetting. The affidavit, my
You're
lord.
for whom?
I am for the, my lord, sericulture department here. Sericulture, my lord.
The respondent numbers?
All the respondents, my lord, here.
Mr. F.A. Hassan Lanet counsel is present for the writ petitioners. Mr. R. Dhar Lanet. Standing counsel,
Handloom,
Sericulture
Technical and
Department.
Sericulture.
Handloom and Sericulture Department, Assam, appearing for the respondent, submit that the affidavit has been prepared and sent for vetting.
Vetting, my lord.
First of, therefore, he be granted 2 weeks further time to bring the same on record by serving advance copy upon the petitioner's counsel.
My lord, date will be fixed, my lord, kindly.
Prayer allowed. This case again on 7th of March 2024. The affidavit on behalf of the department be filed within 2 weeks from today, granting a week's time to the petitioner to file rejoinder affidavit if so advised.
Obviously.
May I please, your lordship?
Granting, affording 2 weeks time.
May I please, your lordship? When the matter pertains to non-regulation of
Affording a week's time to the petitioner to obtain.
matter pertains to non-regulation of service of the petitioner, matter, who has been working as a rural handyman under the PWD department since 6/7,
My lord,
1990.
my lord, the petitioner before your lordship for regularization of service, the service, my lord. My lord, we have received an instruction, my lord, but it is incomplete, my lord. So again, I'll have to seek a proper instruction from the department, my lord. 3 weeks I will need, my lord.
2 weeks, matter. And also date may be given, lordship. Also, may I pray
Fixed
for
date.
date, lordship?
Fixed time also required? No.
Fixed time?
Fixed
Maybe
time.
Fixed time.
Such and such date, 11:30 AM, like that.
No, no, my lord, no.
All right.
Only date, lordship, if it's convenient, lordship.
Mr. D. Buyal Lanet counsel is present for the petitioner. Mr. R. Dhar Lanet, standing counsel PWD Assam submits that although he has received some instructions, yet the same are not sufficient for disposal of the writ petition. Mr. Dhar therefore pays for further 3 weeks time to complete his instruction. Prayer allowed. On the request of Mr. Bhuya, this matter is directed to be listed again on 11th of March 2024 as a fixed time.
Highly appropriate.
May I please, your lordship? Lordship, I have received a copy of the affidavit in opposition today. Lordship, I prefer 2 weeks time to file for filing a reply
Affidavit in opposition filed by
filed by the respondent authorities, Lordship, Animal Husbandry and Veterinary Department.
respondent numbers.
1, 2, 3, and
2,
4.
3, and 4.
All right. And you are appearing also?
3,
So you are appearing for 1 to 4
1, 2, and 4, lordship.
and you are for respondent number 3. All right, you right. Mr. MP Sharma.
Lordship A Chakravarti.
A. Chakravarti, learned counsel for the lead petitioner submits that the copy of the counter affidavit filed on behalf of respondent numbers 1, 2, and 4 has been served upon him only this morning, and therefore he will be permitted 2 weeks' time to obtain instruction and file rejoinder. Ms. M. Kotoki, learned standing counsel.
Animal Husbandry and
Animal
Veterinary
Husbandry and
Department.
Veterinary Department has appeared for respondent numbers 1, 2, and 4, and Ms. A. Laila for respondent number 3. Full stop. On the request of Mr. Chakravarti, let this matter be posted again after 3 weeks.
Obliged.
Obliged, Lordship.
My praise your Lordship. Lordship, the service upon respondent number 4 was complete by the last order. However, Lordship, none has appeared till date. And no affidavit has also been filed. Lordship, this matter pertains to some dues which the petitioner was entitled while he was serving in the HPCL Nagaon paper mill project. After liquidation, some amount was due to him. That Lordship, he had preferred several representations, it was not paid. Now, Lordship, respondent number 4.
You are appearing for whom?
For respondent number 1 and 2, Lordship.
Hmm.
AIDC is the main party, Lordship. AIDC is the main party.
And who's for AIDC?
On the
JK Goswami.
on the
Huh?
last occasion, Mr.
JK
JK
Goswami.
Goswami had appeared.
Where is he? What about 4? Number 4.
4, no one has probably entered appearance, Lordship. 4, no one has entered appearance till date.
Liquidator, why do you want?
Lordship, because the terms of the thing by which we were entitled to certain benefits, for that we have made respondent number 4 a party. Upon
Mr. A. Chakravarti, learned counsel for the writ petitioner submits that the prayer of the petitioner is for release of certain service benefits which he was entitled to after the winding up of the HPC
Lordship.
Limited, and therefore the response of the respondent number 3 would be of critical importance in this case. However, none has appeared for the respondent number 3. That is the AIDC. Mr.
N. Kalita.
N. Kalita, learned standing counsel, Industries Department, Assam is
Lordship.
present for responding.
Only council, Lordship.
Huh?
Not standing council, Lordship.
Not standing counsel.
Me.
Counsel for the respondent numbers 1 and 2 is present. Office note indicates that none has appeared for respondent number 4 despite service of notice upon him, despite service of notice. Be that as it may, considering the importance of the stand of the respondent number 3 in this case, this writ petition is directed to be listed again after 2 weeks as a fixed item. It is made clear that if the learned counsel for the respondent number 3 remains absent even on the next date fixed, consequential orders may follow.
Obliged, Lordship.
For orders, I think 41 and 42.
Right, please, my lord. My lord, these two matters were filed for after post winding up for delivery of property and for filing statement of affairs by the directors. However, the directors never appeared before this court. And therefore, after repeated attempts, the official liquidator had to finally file a report on dissolution by taking necessary compliance. And that dissolution report, my lord, is on the board today by as IA number 3874, my lord.
Where is IA number 3874? So what order is to be passed
So
today?
my lord, if my lord passes the order in the dissolution, the prayer is to dissolve the company now because there are no assets and no claim has been filed by any creditors. The report, my lord, starts at page 12.
All right, can you prepare a draft of the order?
Yes,
We
madam.
can have it
Yes.
On Thursday.
Madam.
On the request of Mr. Sandilin and council.
My lord, can it be next week, my lord?
So and so, let this matter be listed again on 6th of February as a fixed item.
Madam.
Well, here I am seeking some more time to get because the Mayoin Council meeting had to be called. And get everything be passed, my lord. Once it had been passed, then subsequently it in reverse. You have to recall it again, the Mayoin Council meeting, then pass the order, my lord.
But he is due for retirement.
He is due for the when after retirement, he will get them. Only thing is salary. Retirement, that will not affect him, my lord. Only salary part, my lord.
Lordship, already enough time has been given, Lordship.
Because
Till now, nothing has been done.
What is the order you want today?
Lordship,
salary of
What is your, they are saying they will comply with the order. So what is the order you
because
want?
already they are delaying the matter. Already my client will be, he will retire on 30.
So what will happen if he retires? Huh? No, but you have to give a definite.
lordship, because we have taken a decision. Later on, it has been reversed, that has come on our way. We have to recall the meeting again, my lord. Thereafter, that decision had to be taken. The mayor council decision will have to be there. It will be the effect on the order, my lord. We have to pass order according to the mayor council meeting.
Even if it is contrary to court order.
No, my lord, that had to be made as per the court order, because once they have decided as per the court order, then the reversal took place. Yes, sir.
So then, who are the mayor and council members? Have they been included as
No.
parties?
No, my lord.
Why haven't you done it? They have violated the court's order. Your petition is defective. You don't have any choice. You have made the mistake. Now you have to wait.
We wait, but Lordship.
Mayor and council is not above the court proceeding.
No, my lord.
Then
Even-
why they have?
Because it's about the commissioner, my lord. That's the difficulty. When a mayor and council decision, one had to be there.
All right, heard Ms. L. Devi, learned counsel for the petitioner, also heard Mr. S. Bora, learned counsel appearing on behalf of the sole respondent, who submits that since the decision of the mayor and council is coming in the way of implementing the court orders, some more time will be necessary for doing the needful. Hence, Mr. Bora has prayed for adjournment in the matter. Full stop. In view of the specific stand taken by Mr. Bora, that it is the order, decision of the mayor and council, which is coming in the way of implementation of the court's order, the petitioner is granted liberty to implead the concerned person as respondents in this contempt case. It's advised.
May please, your lordship. Lordship, I'm sorry to say, item number 37, there is an interim order, my lord. At that time, forget it, my lord. Interim order will continue, my lord. 37. Obvious, my lord.
Yes.
May I please, your lordship? At the very outset, I'd like to draw attention of your lordship.
What is this? It's a review petition.
The review.
Which order you want to be reviewed? Which is the order?
The order is in. Yes. Huh? Page 148 of our review petition.
148.
Yes.
Yes.
It starts from page 194, man.
The order starts from 194.
Yes.
And
What is the ground of review?
Now, at the outset, my lord, I'd like to point out, I'd like to draw attention of our lordship to one point that this whole case is against the ICAR. They are challenging the order that 2522 is passed by the ICAR. But in the writ petition, the ICAR has not been made party, my lord. Writ petition is 3974, my lord, your lordship.
The whole allegation is against the ICAR. They're challenging the order of the ICAR, but ICAR has not been party.
You are appearing for whom?
From ICAR,
Applicant is the ICR.
yes. Yeah. From the, from Atari, I'm appearing from Atari, Director General.
I've not understood. What is he saying? ICR was not a party in the writ
Page
petition.
180, my lord, it's a party, my lord. I don't know why. Page 180. And 194, Standing Council, ICR was represented. Page 180, my
Check
lord.
up the original record. Give it to them. Writ petition record.
In the review, lordships can have page 180. It shows that ICR was made a party wherein parties' names are there.
Writ petition 3974, your lots of friends.
Check it up. Check it up. Writ petition 397.
Party as
Yes, you have made party Director General.
So ICR is party. Respond numbers 1, 2, and 3 are all ICR officials.
And Standing Council, ICR represented before your lordships and filed affidavit also. Page 194.
Mr. Das, your submission is not correct.
No, it appears from the writ petition, the writ petition, the 3974.
What is the ground for review of the order? What is the ground?
Ground I am coming. Our main submission is that in this order, the honorable court has, the court did not notice vital vital facts of this case, some vital points has been missed. That is why that the points are, the number one, that this writ petitioners, the status of the writ petition. Who are they? What is the relation between the ICR and the writ petition? There is no connection of ICR with the writ petition. Number one. Number two, that in this case, they are involved hundreds of crores of rupees, illegal inflow of hundreds of crores of rupees from the government fund in this case. And the writ petitioners, they are not central government employees. They are employees of Assam Agricultural University. So their claim, the allowances they are demanding.
Take appearance slip.
The allowances they are demanding, that the ICR should continue the payment of SDA, SCA, special DA and special compensatory allowance. Those are applicable only to the central government employees.
No, it's all right. Now, please understand, in review petition, the scope is extremely limited.
Yes,
These are arguments you can take in an appeal. But in a review petition, the court once passed a judgment, cannot go into all these things. You know the law. Then what is the point in wasting time? If there is a clerical error somewhere, some mistake, then the court will correct in a review. Supposing the ICR is not even heard, something like that.
No, in this case, they are one of the main basis of this case is that there is a discrimination. Discrimination between the petitioner with other employees of the KBKs of this group. But that in that connection, one letter was placed before this court at 25/7/2023, 2022. That letter was not considered by this court.
Then it is an illegal judgment at the most. It's not a case where every judgment there will be something here, something there. Review jurisdiction is not meant for this. You may be unhappy with the judgment. It's perfectly all right.
Yes.
But then you appeal the remedy now, which is permissible under the law. Coming to the same judge again and saying that you didn't do this, you didn't do that. That's not the way. You may have a grievance. You challenge it.
Our main grievance is that.
Whatever be your main grievance, secondary grievance, tertiary grievance, the point here is the review jurisdiction, the law is very well settled. Review jurisdiction, court can use only to correct some clerical error, mathematical error, or somebody fundamentally the party against whom the judgment is passed is not even a party, is not even heard. But otherwise, a rehearing on merit is not possible in review jurisdiction. So therefore, why are you insisting on it? You know the law.
Yes.
You know the law. That's the law.
But our
And if you are asking the court to write out again another order on this, this could even create further problems in even if you prefer an appeal, that could create further problems. Because this court, if it deals with this and clarifies the matter and then declines, then it will further shut your ways in the appellate stage. Therefore, the other day only I said that you may have your grievance, you may have a point. The courts decide issues on the basis of what is before the court, what is argued, what is presented. So on that basis, if you feel that something has not been.
Main grievance is that on the day of that hearing,
Order result. Yes, next matter.
One later that 25/7/2022 was placed before the court, but it was not considered.
All right.
That should have been considered.
All right. Order result.
The two judgments I am having, my lord, just for you. Deeply obliged.
Give the appearance.
Matter 45.
May it please the Lord. In this case, was a notices were issued to the respondent. So there are three respondents, Lordship. Perhaps respondent number 3 has made a communication to this honorable court directly, Lordship. That is a flag A, Lordship. And respondent number 2 has denied to accept the notice, Lordship. That is flag A.
Who has made correspondence directly?
Lordship, it's actually a direction was made to the government and Director of Health Services to complete the Lordship departmental proceeding within a particular period of time, Lordship, and to pay the pensionary benefit to the petitioner, Lordship. Yep.
This is the health department. What is this, Mr. Nath? Again, your officers are directly writing letters to the registry in contempt cases.
In fact, OM has been issued and it has been circulated to all. They have been instructed not to communicate.
Please, can you please get the OM?
Yes, yes, I
We'll take some strong action against this person.
I have a copy, my lord.
Whoever he is. Or rather, why don't you take some action? We'll have it on Thursday.
Lordship. Lordship, may I have the copy of the communication, my lord?
Yes, yes. Mr. R. Phukan, Learned Counsel for the petitioner is present and has pointed out that the respondent number 2 has issued a direct communication to the registry after receipt of notice in connection with contempt case number 310/2023. The other respondents have declined to accept notice.
Lordship, perhaps the respondent number 3 has made direct communication, Lordship. Respondent number
The respondent number 3 has made direct. What about the other respondents?
Respondent number 2, Lordship, denied to accept the notice, Lordship. Refusal.
Mr. Phukan further submits that the respondent number 2 has declined to accept notice. Perusal of the records prima facie establishes the claim of the petitioner's counsel. Full stop. It is not understood as to how, despite repeated orders and government circulars issued on their behalf, the officials are addressing direct communication to the registry in the matter of in connection with contempt cases. Full stop. Mr. D. Nath, Lanet Senior Government Advocate, Assam, prays for posting this matter again on 2nd February
Second, my lord.
2024, so as to enable him to look into the matter and address the court. Let this case be listed again on 2/2/2024 by reflecting the name of Mr. D. Nath Lanet Jia Assam in the cause list. In the meantime, register to furnish all connected papers of this case to Mr. Nath.
My lord.
Item 46.
But in item 46, the Honorable Court has directed the respondents to consider the case of the petitioner for providing pension, my lord, family pension. The authority, they have already processed that and they have already sent the matter for seeking approval for the AG, my lord. That response from the AG, they are waiting.
Here, my lord. My lord, here we received a pension proposal, but there are some discrepancies in the proposal. First of all, my lord, the husband of the petitioner, he was removed from service in the year 2012. So without revoking that order, my lord, they have forwarded the proposal as a normal family pension, number one. Number two, my lord, the person is missing from 2007. So in the writ petition on this honorable court directed the department to consider the case of the petitioner in terms of section 108 of the Evidence Act. So that presumption has to be drawn that the person is dead, my lord. So in this case, my lord, a death certificate is required because she is claiming for family pension. So in the proposal, there is no death certificate. There is no legal hair certificate. And most important, my lord, the order by which the husband of the petitioner was removed from service, that was not revoked, has not been revoked, my lord.
So has that aspect not been dealt with in the court order?
No, my lord. And my lord,
Where is the order of the court?
Relevant portion, page number 13, my lord. Page number 13. Relevant.
and moreover, my lord, today I have received another writ petition which the petitioner has filed. Here they have challenged that they applied for death certificate. And my lord, that their prayer has been rejected by the, my lord, Joint Director of Health Services, that the death certificate cannot be issued because you have to approach the competent court below for that presumption that the person is dead in terms of section 108 of the Evidence Act. And for that,
It will take time because nothing was sorted out.
and they have filed a new writ petition, my lord. A copy has been served today, my lord.
Mr. F.A. Laskar, learned counsel for the petitioner is present. Mr. D. Nath, learned counsel representing the respond numbers 1 and 2, is it?
4 and 5, probably.
4 and 5.
Yes.
Submits that the government has already forwarded the pension papers of the petitioner to the office of AG Assam, and a response is awaited in respect thereof. Mr. M. Hassan.
A. Hassan.
A. Hassan, then a counsel appearing for the respondent number
1.
1 submits that although his client has received the pension papers forwarded by the government, yet there are some serious anomalies in the proposal, as a result of which the same could not be approved.
And we have returned the proposal, madam.
The papers are accordingly being returned back. Mr. Hassan has also pointed out that the writ petitioner has filed WPC number.
It has not numbered. It has not been numbered. Today, copy has been served, madam.
Petitioner has
Morning.
filed another, the petitioner has filed another writ petition before this court, making prayers which have a bearing on her claim for family pension, and therefore both the matters be listed together. In view of the above stand taken by the learned counsel for the respondents, the registry to verify and list this case again after 3 weeks, along with the connected writ petition, which is yet to be numbered, filed by the petitioner, which is yet to be numbered.
Item
Ma'am.
47.
Obliged.
Obliged. Which your lordship, appear for the responding lordship, has been challenged by the state, and the state by the division bench, your lordship. A single bench judgment.
Mr. A. Boro, learned counsel for the petitioner is present. Mr. A. Das, learned counsel appearing for
The sole responding, your lordship.
sole respondent submits that the order of this court has been stayed by the division bench in a writ appeal preferred by the state,
I provided a copy, your lordship.
and therefore awaiting the final order in the writ appeal, this matter be adjourned. Mr. Das has also produced a copy of the order dated 11/1/2024, passed in IA bracket civil bracket close 3787 of the 2023 by the division bench. In view of the above, let this matter be listed again after 8 weeks or after disposal of the connected proceeding pending before the division bench,
Much obliged.
whichever is earlier.
Much obliged, your lordship.
Here in this case, we have taken steps upon the respondent number 2 and 3, lordship, but service is awaited, lordship, as per office note dated 8/1/2014, lordship.
Await service report on respond numbers 2 and 3, list again after 3 weeks with appropriate,
Obliged.
4 weeks with appropriate of this. Yes, 4 weeks, sir.
My lord, here in this case, I entered my appearance on behalf of petition number 4 today itself. 2 weeks time may be granted for filing affidavit.
None appears for the petitioner on call. Mr.
R. Islam.
R. Islam, learned counsel has appeared on behalf of respond number 4 and prays for 2
2
weeks
weeks time.
time to obtain instruction, file affidavit. Mr. H. Das, learned counsel.
HK Das, my lord.
HK Das, learned
No,
counsel.
one issue is there, my lord. Our name has been shown as SCJC in the cause list, but Mr. J.K. Goswami accepted notice for district and session judge in the last order.
All
For
right, Mr. H.K. Das, learned SC Guwahati High Court is present on behalf of the official respondents. Let this matter be listed again after 4 weeks.
March.
You are Mr. R. Is present for respond number 2. Yes.
51, Lordship, IA for substitution of legal hire, Lordship. Petitioner, Lordship, matter relates to disciplinary proceeding where the deceased petitioner has died, Lordship. Penalty was removal from service. So if that penalty is gone, Lordship, the legal hire will get pension at least, Lordship. So IA for substitution of legal hire, wife has filed a petition, Lord. I.
He expired after the order of removal, dismissal from service was
Yes,
issued.
yes. He has expired, Lordship, 1 month back.
5/11
5/11/23.
2023.
After filing of this writ petition.
You have any objection?
No, my lord.
All right, heard Mr. G.J. Sharma, learned counsel for the applicant. This IA has been filed with a prayer to substitute the legal heirs of late Anirban Roy, who expired on 5/11/2023 during the pendency of the connected writ petition. I have perused the statements made in the IA. Mr. Sharma submits that the applicant is the wife of the deceased employee and he doesn't have any children, is it?
Children, Lordship, was already made a party, Lordship. The son, he was already a party in the writ petition. He was already a party in the writ petition as petitioner number 2.
2 years.
And
So only the wife.
is one of the two surviving legal heirs. It is also the submission of legal heirs of deceased Anirban Roy. It is also the submission of the applicant that the son of the deceased is already implemented as petitioner number 2 in the connected writ petition. Miss
L. Sharma.
L. Sharma, Mrs. L. Sharma, learned counsel appearing for the opposite party submits that she would not have any objection if the prayer for substitution is allowed by this court. In view of the above, the prayer made in the IA stands allowed. Let the applicant herein, namely Srimati Olympia Roy, that is the wife of the deceased, be implemented as petitioner in place of the petitioner number 1 in the connected writ petition. Applicant to files amended cause title in the writ petition. IA stands disposed of.
Much obliged.
Yes, there are other cases fixed before this.
My
court.
lord,
When is it?
8-2 fixes, my lord, but in this case, delay and laches are there, my lord. That is our main defense, my lord. Because the writ petition was filed
That's
after
correct,
2
but
years.
since the series is fixed,
My
I
lord,
don't
my
want
lord, my
to
lordship can fix.
express any opinion
My
before
lord.
that. Heard Mr. S.B. Lashkar and counsel for the petitioner, also heard Mr. S. Dattalar, standing counsel. PNRD Department Assam, who submits that similar matters are fixed before this court on 8/2/2024. And therefore, this matter be also tagged together. On the request of learned Department Council, let this writ petition be listed along with WPC number.
I'll provide, my
So and so on the batch of connected writ petitions fixed on 8/2/2024. You have to make a table of cases. What are the issues?
Yes, yes.
So that we
My
can
lord,
pass
I'll.
judgment. Yes.
Obliged.
I am sorry, my lord, in item 40, my presence may be.
Highly
recorded.
obliged.
50.
Why present will be recorded?